Good afternoon everyone, thank you very much for tuning into my latest video. I really appreciate it. Thank you very much to everyone that continues to comment, shares, likes and subscribes. I really do appreciate it. Apologies for the delay in this video everyone. I had to go through the case law and the legislation. It's obviously with regards to everything else that's going on. I didn't have, my full attention wasn't on obviously reading this, but I'd like to obviously start by just giving a big thank you and a big shout out to Neil, the subscriber that provided me with this information and allowed me to obviously give him a call so that he could talk me through his own experiences, and because it's obviously going to help a lot of people this, because I mean I know that me coming forward and obviously saying that the processes are wrong and this is happening and that's happening, and I can even tell people how to challenge these things just through your universal credit account. However, as I've said a few times now, people run into case managers who really couldn't give a shit, like, and they just tell them that this is correct, these deductions are lawful, this is the way it is and there's nothing we can do to stop it. After spending quite a lot of time looking through this case law, that is not true. Actually, the further you read into the case law, the more you realise they were actually breaching the legislation and their own processes. And I've took some screenshots here. I've got the article that the case law is based on, or the woman who it's based on. She was a former police officer who had obviously found herself in universal credit due to health conditions. And she was at the mercy of these deductions. She was having these deductions taken off for, I think it was water arrears, energy arrears, and she obviously couldn't afford to live. But like I say, after reading through the case law, this is so unlawful. Well, actually, it goes in, one of the managers in the case law, like in court, had basically said that it was lawful. However, the practices they weren't very good with regards to the process because of the way they hold information on people who are in debt. But I'm going to get into all that obviously as the video goes on. I want to start just by going through a few screenshots. I mean, this is another reason why this video is taking so long, because, well, first I had to obviously speak to Neil. Secondly, I wasn't sure on how I was going to put it into a narrative to get it across to you in a way that it could be understood. And then I decided to start with notes. That didn't work. I threw the notes away, and then I decided to just come off the heart. Then I decided to I was going to need the notes, but I'd thrown them away, so I had to start again with that. It was just an absolute disaster. And I think probably the best way, as I'm no lawyer, I think the best way is probably just to go through it sort of piece by piece. And I mean, we can take a look. There's a Human Rights Act, because it's the Human Rights Act that this obviously needs to be challenged on. And I'm just going to go into, if you just bear with me a second here, I'm just going to go into it's the Social Security Administration Act. No, it's not. It's the Universal Declaration of Human Rights. And I'm just going to get that up. Just bear with me a second here. So this is from the United Nations, and when you click on this link, it comes up: peace, dignity, equality on a healthy planet. I mean, it's obviously delusional. Now, this is the Declaration of Human Rights. The Universal Declaration of Human Rights is a milestone document in the history of human rights, drafted by representatives with different legal and cultural backgrounds from all regions of the world. The Declaration was proclaimed by the United Nations General Assembly in Paris, on the 10th of December 1948. As a common standard of achievements for all people in all nations, it sets out for the first time fundamental human rights to be universally protected, and has been translated into over 500 languages. The UDHR is widely recognised as having inspired and paved the way for the adoption of more than 70 human rights treaties applied today on a permanent basis at global and regional levels, all containing reference to it in their preambles. I don't want to go into the preamble too much, but just reading that, that sounds good, doesn't it? It sounds like, yes, that's something that I think most of us would agree that we could get on board with. Only, as we can see, as I've seen working within the processes in the benefit system, and obviously the claimants of the benefit system that are at the mercy of those processes, I'm sure you'll agree that we've veered off course a little bit from what that says. Now, the preamble, like I said, I'm not going to get into it too much. It's just about what they talk about, and or what it's supposed to be about, and why they've done it and all that. It's just another breakdown of what I've just said there, basically, or a expansion on what I've just said there, rather. So what I'm going to do is, I'm just going to, I think it's Article 22 to 27 that's relevant to this particular video. Now, the reason I'm starting off with this is because these are things that are woven into the fabric of our society. This is what democracy and freedom and equality and all the rest of it's supposed to be bloody based on. These are the rules for, well, to run a civilised and fair society. But see, when I was reading through some of these articles within this document, I mean, there's work coaches, case managers and agents that are breaching it multiple times on a daily bloody basis. Listen to this. Everyone as a member of society has the right to social security and is entitled to realisation through national effort and international cooperation and in accordance with the organisation resources of each state, of the economic, social and cultural rights indispensable for his dignity and the free development of his personality. I mean, even just within that one article, people are being breached within universal credit in all kinds of ways by work coaches and case managers. Right now, Article 23, it's an expansion upon what I've just said. Everyone has the right to work, to free choice of employment, to just and favourable conditions of work and to protection against unemployment. Right, so that's number one of Article 23, right? So you've got the right to work and you've got the right to free choice of employment. But when you actually look at the way the commitments work within universal credit, you can see that that's not being followed, because the amount of, well, I'm still getting it now, people are emailing me to say, look, because I'm on 16 hours, but my work coach wants me to do 25, do I have to do it? So, well, no, you don't. And that Article 23 is what proves that you don't have to do it. There's more to that, I'll just go into in a second. Against everyone without any discrimination has the right to equal pay for equal work, right, okay. Everyone who works has the right, I mean, that's getting into the cost of living, and that's bound to be being breached recently with the cost of living and the way inflation's gone and the wage rises that haven't came, that should have came. I know they've put it up, but nowhere near enough. Everyone who has the works to right and favourable remuneration, ensuring for himself and his family an existence worthy of human dignity and supplemented if necessary by other means of social protection, right? I mean, it's just, with human dignity is gone from, I'm not saying all work coaches and case managers are like that, because they're not, but there's not a lot of dignity within those job centres these days, or on that telephone line. Everyone has the right to form and join trade unions for protection of their interests, right? Okay, so Article 24, everyone has the right to rest and leisure, including, and listen to this, reasonable limitation of working hours and periodic holidays with pay, right? So basically, what's that? Reasonable limitation of working hours. So in other words, you pretty much, you're the one that decides how reasonable that should be and when you should limit. I know everyone's different. Some people like doing 70 hours a week. Some maybe only want to do 50. Some, like myself, want to do as little as they can so that they can get by and to obviously do other things that they want to pursue. But that being said, this is within this document to say that you are allowed to choose that. Reasonable limitation of working hours. Now, when you've got a work coach that's coming to you and saying, well, you're only doing 12 hours, we actually need you up to 22. Why that particular? I would just say, look, why do you need me up to 22? And I would refer them to this article, and I'll get these links posted into the description so that you can look at this for yourself and you can obviously use this stuff, because there's quite a lot to go through here. I'm not sure how long this is going to last. But obviously we need to go through it, so that, because when people are contacting me and saying, look, Alan, I'm having a time out with the case manager or my work or whatever, there's I don't know the legal terminology that they need. Well, this is it, and this is where you find it, and you can show them this stuff. Everyone has the right to a standard of living adequate for the health and well-being of himself and of his family, including food, clothing, housing and medical care and necessary social services, and the right to security in the event of unemployment, sickness, disability, widowhood, old age or other lack of livelihood in circumstances beyond his control. Right? With that, we can bring in the apparent cure that was rolled out a few years ago, who they thought they were doing the right thing, and they got these shots, and now some of them have got sick and they can't work. That's out with their control, because they have followed the guidance from the state, and it was always just guidance, let's not forget that. They need to follow the guidance of the state which they have done. I mean, people like me chose not to follow the guidance of the state, we were ostracised. However, the people that did follow the guidance of the state should absolutely be taken care of by the state, but they are not, because of some of these work coaches and the processes that we've been that's been put in place. Now, this is the reason why everything's breaking down, because people don't care, they're not bothered. As long as their bank has got the money in it at the end of the month, they're not really bothered. They don't care about any of this stuff. In fact, half these work coaches probably doesn't even know this existed. This stuff exists. But we need to start sort of getting to the realisation that it does exist and that you've got rights. Not only have you got rights, but you've got power. And when you start to learn about your rights, you take your power back. They're both interchangeable, in my opinion. Motherhood and childhood are entitled to special care and assistance. All children, whether born in or out of wedlock, shall enjoy the same social protection. Right, that's not really relevant. Everyone has the right to education. Right, so this is just going into education. So once it's for Article 22 to 25. Right, so just based on what I've read from that, this is being breached. Even just from attending appointments from work coaches, the way they're going about their business, the way they're going about their processes, they're trying to push people further back into work. They're breaching people's human rights, and it's the Human Rights Act 1998 that this needs to be challenged on, but I'll go into that obviously when I come to the case law. Now, the next part, I want to just sort of go in and we can start by, I'll go into the case law in a second, but I want to go through I'll just read an article that The Guardian posted on the lady in question here. That's this case law is based on. I can't see her name in the case law, but I'm assuming it is. So a disabled former police officer has won a legal charge against the Department for Work and Pension over its policy of allowing utility companies to automatically deduct hundreds of pounds a year from individuals' benefits without their consent. Helen Timpson of Leicester argued it was unlawful and immoral that the DWP enabled Watergy and Energy Funds to draw down up to the 25% of a claimant's monthly benefit income at source without undertaking any form of check with the claimant, which, according to the case law, they are not allowed to do. They're not allowed to do it. It is against the law to take deductions that are more than 25% of a person's benefit. That is a fact. It's in the case law, and as Neil correctly pointed out, the case law is what makes the law, and it's just asking me. It's asking me to register. All right, okay. Understood. Hundreds of thousands of claimants are understood to be subject to the deductions. Yes, absolutely. That's why I'm here. The High Court ruled that the DWP's operation of the scheme was illegal because officials failed to give claimants the opportunity to challenge the funds. Actually, when I was reading in the case law, the manager who stood in court for the DWP had tried to say that actually it was lawful. However, the processes was flawed, and the way that they collected data on with regards to what people owed, what their income was, what their wages were, etc, etc, etc. They just didn't care. It was just all put onto a spreadsheet. And by law, what they're supposed to do is they're supposed to contact a claimant. And it's this third party deduction, which I'll come to, it's a last resort. It's not an option for creditors to retrieve debt, but that's what they seem to be doing, along with the fact that the DWP and the government are purposely defrauding people from their benefits with this very system, whether they owe the money or not. Now, it was illegal to give claimants the opportunity to challenge for. So, like I said, they've got to give you a call, and first and foremost, they need to let you know exactly how much you owe, and then you need to respond whether you want to challenge whether you actually owe the debt or not, whether the debt's payable. And this is why Neil contacted me, because Neil, he had a council tax deduction on his benefit, and he basically said, he says, look, I'm not refusing to pay council tax here. That's what he told me on the phone. I'm just saying, where is the contract that I have signed basically telling me or mandatorily forcing me to pay that payment for council tax? Because we're running the law contracts. Everything's consensual. No one seems to know where the contract for council tax is. See, we come into the world believing we need to pay council tax. Everybody pays council tax, so we all pay council tax. But no one seems to know why we pay it. Oh yes, of course it's to empty your bins and water here in Scotland, whatever the case may be. But there's so many more taxes that they're put. It's just a never-ending stream of taxes that they're putting on. But I mean, I've lost my train of thought there. Yeah, it's absolutely ridiculous how they're doing this to people. Yeah, with council tax, sorry. So everybody just thinks that we need to pay council tax, and your consent's your payment. So you're paying it, so you're giving your consent by paying it. We actually tried it here. We'd said, look, to the council, look, we're not liable to pay council tax because there's no contract for it. They sent a message back, or a letter back, saying, oh, something to do with data protection. It's like, data protection's got nothing to do with that. We're talking about the law of contracts here. That's just somebody that's been told by their superior, thinking that, oh, they're just shit, they're idiots, they know what they're talking about. This is the way they look at you, and this is why we need to start getting grips with this stuff. And I'm not saying it's not much fun to read through case law, it really isn't. It's pretty boring, like, I'll be honest, but we need to know what the score is here. And Neil has had his deduction removed. He challenged it, and he went, see, this is what he said as well, and it was brilliant. You need to take it a battle at a time. There's no point trying to fight something on 3 fronts. You've got to take it a battle at a time. You need to obviously win your smaller battles, and then the bigger victories come later. So what he done was he put a message on his journal, as we all do, saying that he needed to challenge council tax, and it came back like it would, oh, data protection nonsense, you need to pay it, and he just kept taking it through, until he got it to court. And actually, when he first contacted me, the decision hadn't came through. I think it was about 2 days after. Don't quote me on that. It was roundabout. There wasn't a lot of time where he'd contact me by email to say that he'd got the result had gone through and the deduction had been removed, because he had successfully proven that there was no contract in place for him to pay this deduction. So the deduction had to be removed, and that's in the case law. They first and foremost need to prove that you owe that money. If there's no contract that you have signed to say that you will pay this money, they cannot prove that you owe that money. It is that simple, and people need to know this stuff. And I'll tell you something right now, if this video gets to enough people, they've got serious problems in their hands with this, because they are breaching their own legislation and their own processes on a daily basis. Probably hundreds of thousands of times a day, and that's maybe a bit much, but thousands anyway. And this is what they're doing. Sorry to go off there, but it is important. The judge, Mr. Justice Kavanagh, said the lack of opportunity for claimants to provide DWP officials with evidence as to whether the deduction was affordable, whether the debt was even owed, or to discuss more favourable alternative repayments methods was a breach of obligation of fairness. Yes, exactly, because the TPDs, as they're known, third-party deductions, it is a last resort. It's basically like, I remember a guy I used to know, he's dead now, but he used to rig his electricity meter, and now and again it would blow, and he would have to get an electrician to come out, like the company would send it out, and they would obviously sort it out, and they would automatically set up a direct debit for £5 per month, and it was to cover his costs, because as long as you offer something that you're willing to pay that, there's nothing they can do. People used to tell me that just applied in Scotland. This was in Leicester, so the case law, it said that in that case law, that you can offer what you can afford, and they have to accept it. So the judge, Justice Kavanagh here, he outlined, that's in the case law as well, that whether you have to obviously let them know how much they owe and whether it's even owed in the first place. And the person, this company, they need to personally contact the claimant or the person that owes the money before they can even put any of these deductions on there, any of them, whether it's water, whether it's arrears. I think like fines, I was reading in the legislation that Neil had sent me as well, that fines are, you can't do anything about that because it's obviously through a court of law. I didn't read any further on that, but I would imagine it was just for fines. Everything else has to go through, I can't remember the article number, it's written down, the process basically, or what Justice Kavanagh had outlined there, which they're not doing. And as the manager states in the case law, it's basically done in a Google spreadsheet where they'll have all this information, and it's not even really the way I could sort it out. The way I looked at it, it was like it wasn't even, they don't know what people owe. It's just the whole spreadsheet seemed to owe a certain amount, and it was almost like they would try and bloody divide it between the spreadsheet to then deduct it from all the people to ensure they get their money back. I mean, that is what it looks like. I've said that for a while now, that with regards to the deductions on people's accounts or on their claims, on their statements, their universal credit statements, it does look like they are trying to accumulate a certain amount within each assessment period, which is why The deductions might fluctuate, but the amount never. It's always usually the same. Not always, like, but it usually is. And I would wonder if that's connected to the process with the spreadsheets. It probably will be. But like she says, she's trying to say it's lawful, but it's not. It's unlawful because they need to contact people. They can't just assume and just put, well, you owe this. I mean, the amount of people I used to speak to, I don't even know who this is going to. And it's like, well, neither they are. It doesn't say. And they don't even know whether they owe the money. And then some people would say, oh yeah, I can remember a few years ago I owed money for this, owed money for that. And I would always say to them, look, maybe you do owe it, but you need to phone them and ask them if they are receiving a payment from you on the 16th or the month or whatever it is, whatever it may be. And a lot of the times people would do it, and they'd be like, no, we're not receiving anything, but it was still coming off the benefit. This is fraud. This is fraud, and the case law proves it. Okay, so alternative, but it's a breach of all the obligations of fairness. Timson had suffered benefit deductions on several occasions without her consent, right? So the vast majority of people who watch these videos will have had that happen to them, like, certainly the ones that were on Universal Credit anyway. On one occasion, an energy company wrongly deducted £81 a month for a year and a half for non-existent debt, and that relates back to what I just said about the bloody spreadsheets. It is wrong. It's all wrong. These energy companies are criminals. They are bloody criminals, and they think that this third-party deduction system is in place is for a way for them to get their money back and steal from people or get money that's not even owed. It's not for that. It is a last resort to ensure that you can obviously cover the cost of your energy, what you're using. That's basically what I got from the case, what it looks like. So that they're obviously getting something from you, because it's not even their energy, it's the Earth's. It's absolutely ridiculous. They put in these meters and tell you this is how much you owe us. It's bullshit, like, honestly. When she asked the DWP to stop the deductions, it refused in contravention of its own guidance, arguing it had no power to do so, which is nonsense, because I've read it in the case law. They absolutely have the power to do so. And that Miss Waterman that Manuel was talking about there, she had basically said that she had sent out a communication to all the team that basically saying that the claimants were being wrongly advised that we could not stop these deductions when they can, because Neil's call the other, or Neil's contact with me with regards to his deduction getting removed proved it. And this is why, and I know this, and like I was saying before with Neil, you need to fight a battle at a time and win the smaller battles, and that's the thing, people, you need to keep going. I know it's disheartening sometimes when you get a letter back to say you're not entitled to this, or this is correct, you owe this, or whatever, but you've got to keep on pushing it, you've got to keep on going, because it's true what he said, that the judge is not looking, the judge isn't, it's neutral, he's there to make sure the law's being followed. If you've got a case, and a good case, and you can prove that this debt, they can't prove to you, or if you can prove that you're not obligated to pay that debt, or you don't owe that debt, then the judge will help you getting removed. It's all about conduct, obviously, it's like that, anything in life, but it's true what he says, the judge is on your side, provided you've got a good case and you conduct yourself correctly. So, on another occasion, she challenged the benefit deduction made by Southern Water in respect of arrears and ongoing usage. When the deduction was eventually removed and replaced with a more manageable standing order arrangement, her debt payments reduced by £31 a month. But that doesn't sound like... Well, I mean, it doesn't really say whether she has agreed to that or not. I presume she must have done. Timson, who was unable to work because of physical and mental health conditions, said that far from it being in her interest to have the deductions made, it had left her with little control of her finances and made it difficult to buy sufficient food, pay the rent, or afford to travel to hospital appointments. I revert it back to Article 22 or 23 in the Human Rights document that's been breached based on that. So they're breaching their own legislation. The court heard that utility companies, I'll get to the legislation in a minute. The court heard that utility companies would request third-party deductions by submitting Excel spreadsheets, so it was in the case work, to the DWP containing names of the large numbers of customers who had fallen into arrears. So this is it. These bundles of debtor names contain no information on the nature of the debt or the customer's circumstances, although the DWP is required to approve deductions only if they're in the interest of the claimant of the family, and there's guidelines on even that. The court heard officials greenlighted the deductions without consulting, informing the claimant, or making any attempt to assess whether it would be in the claimant's interest. Right, okay, bear with me a second, I'll get to these screenshots that I'd taken here. Albums. Sorry, just bear with me a second, I just need to find that. It's not far away. And that's the Human Rights Act. The DMG. Where is it? Sorry. Oh, no, that's not it either. Yeah, when that's the bit just before that, this is at 116. We have become aware the claimants who are subject to third-party deductions for fuel and water are being told incorrectly that these deductions cannot be stopped by the DWP. Also, claimants are not being given the option to dispute a decision or offered a mandatory reconsideration decision, so they are not provided with a formal decision refusing to stop deductions, which would then attract appeal rights. If a claimant contacts DWP to stop a third-party deduction, you should consider the following. Is the claimant requesting the stop because they're disputing the debt? If so, guidance on dispute of the liability, paragraph 43 must be followed, which is just it's the whether they owe the money or that. It's just those guidelines that I'd put out before. Sorry, I do apologise here. It's always the same when I get these bloody screenshots up. Where is it? No, that's the case law for. Yeah, okay, so here's the right to challenge a TPD decision, right? Okay, so a claimant may apply to the Secretary of State for review of a deductions decision under Section 9 of the Social Security Act 1998. The defendant refers to these reviews as mandatory reconsideration. If a review succeeds, the TPD decision is retrospectively changed with effect from the date of its implementation. In other words, following a successful review, the claimant will be paid the benefits he had held back and paid to the third party pursuant to the TPD. So there it is. It's in the case law there that if it's proven that that's not been, this is the amount of people that tell me, my own being one of them, there's no point in pursuing this. That's the proof. That's why you need to pursue it. If a review application is unsuccessful, there's a right to appeal from the determination to the First Tier Tribunal Act under Section 12 of the Social Security Act 1998. A claimant is not liable to pay the defendant's cost if such an appeal fails. The Secretary of State also has a power to vary a decision made under Regulation 35 of Schedule 9 to the 1987 regulations. This power, which is called the power of supersession, is contained in Section 10 of the Social Security Act 98. The power to supersede differs, and there's actually got a name. You've got the Carl Toner principle. It's known as. It's a principle that permits civil servants to act as the Secretary of State. I'm sure that's caused its problems. Just be giving them that bloody power. Because it's I'm telling you, like, I've seen it. I've seen people being given a team leader's job and think they're better than everybody. So that'll definitely cause its problems. The Human Rights Act, as 1998 is thus. Section 6, paragraph 1 of the Human Rights Act provides that it is unlawful for a public authority to act in a way which is incompatible with a convention right. Convention right. So there it is. It's in the Act. A person who claims that a public authority has acted or purposes to act in a way that is made unlawful by Section 6, paragraph 1 may bring proceedings against the authority under this Act in the appropriate court or tribunal, or rely on the convention right or rights concerned in any legal proceedings, but only if he is or would be a victim of an unlawful act, which this is the claimants of these benefits are victims of unlawful acts. That is within the case, the casework. It's there. It is absolutely there. Well, there it is. There. It's in the Human Rights Act as well. If the proceedings are brought in an armed collision for judicial review, the applicant is to be taken to have sufficient interest in relation to the unlawful act only if he is or would be a victim of that act. Right, okay, we've established that. Right, so human rights are being breached. Now, let me get to the next part of the research. There's no point going into any further than obviously how far I've gone with that. I'm just going to briefly go into this case law again because there's some certain things in here that obviously need to be read out. Just bear with me a second here. 1987 regulations. Deductions from benefit and direct payments to third parties. Deduction be made from benefit and direct payments may be made to third parties on behalf of a beneficiary in accordance with the provisions of Schedule 9 and Schedule 9b. Paragraph 1 of Schedule 9. The interpretation prior states that family in the case of a claimant who is not a member of family means that the claimant, the power to deduct TBDs applies to specified benefits. Right, okay, so The specified benefit may be paid direct to a third party in accordance with the following provisions of this schedule in discharge of a liability of the beneficiary of his partner to that third party in respect of housing costs, miscellaneous accommodation costs, hostel payments, service charges, fuel costs, water charges. Right, okay. I mean, it's just, all it is that's the Human Rights Act that I just read out there. There was a process here with 6 thingies. The discretion to impose TBDs for fuel and water debts, that has been granted to the defendant by the 1987 regulations, of course, exercised and practised by departmental officials, decision makers known as DMs in the document, pursuant to the Carl Toner principle that I've just mentioned, that gives them the powers that the Secretary of State has got. The DMG is a document, apparently you can read one part of it on the government website, but there's another part of it that's on the DWP intranet, which is unfortunate, because if I'd still had my computer, I would have been able to look at that. Yeah, decisions, claims and applications are made by the Secretary of State, but as by the Carl Toner principle, there's people that can act on his behalf, so it's not really by him, but there will be processes in place. I mean, with the rest of the shambles we've had in the country, I'm not sure how well they're being followed. The decision makers take all necessary action on behalf of the Secretary of State, including gathering information, making decisions on claims and applications. Well, they're obviously not gathering information because there's not enough people that are being contacted when these deductions are on there to make sure that they should be there. It's already been laying out. That's for fuel costs. That's not it. Yeah, I mean it's a 75-page document. This, like, yes, it's here. So third party, this is like the interest of the family part. Third party deductions will always be in the interest of the family where there's a risk to health or safety, for example, where the family includes children under 11. I don't know how many parents with children under 11 with these deductions on there that were struggling, that I've said many times, that were shouting in the background that they were hungry. People over 70, people who are disabled, and people who are long-term sick. They're doing it to all of the above. This is not just me. This is not just me just reading it. This my own grandmother had to deal with this stuff. She got her money back, but it's not the point. She only got it back when we pointed it out, or when my uncle pointed it out. Superseding the third-party deduction, well, it's already established that they don't need to pay the defendant's costs. And that's another thing that I'd seen in this case law as well. They were saying that because it was like a second phase, like there was one with the bank, where the bank were up at court and they were taking deductions, or they were in unison with a company that was taking deductions, and they tried to say that they weren't breaching the legislation of the Human Rights Act because it wasn't actually being taken from their benefit. The benefit was being paid into the bank, and the money, or the deduction, was being taken from the bank account, which has been is nonsense because it didn't go their way. So, and this is the Universal Declaration of Human Rights. No, that's just the one. There's a legislation here though, and then they've got there's something called the article. There was something in the case law I'd seen, Article 1 of the First Protocol, and that was just protection of your. This is protection of your property, your right to enjoy your property peacefully, and it's also got in there with regards to what you can use for your benefits. I mean, your benefits are protected through this as well. So people need to know this stuff. Like I say, I'm going to post all these links if you want to have a read through it. That's entirely up to yourself. And that again is just the Human Rights Act. And then here, this was another one that I'd saved actually. This is the right to challenge the third party deductions. I've already read that out. And this is just another little part that Neil had obviously sent me with regards to, after everything we've said with regards to the legislation being breached, proceedings not being followed, people being lied to, money being taken off that shouldn't have been getting taken off, all that's going on. People are helping them do all that, and yet the Sun aren't very credible, but I can believe this. Planning a summer holiday, if you're on Universal Credit, you'll need to be aware some rules your payments could be stopped. Now, when was this put actually? The 21st, this is just recent, so they must have changed it again. It's important that you tell the Department for Work and Pensions if you're going abroad, because it could count as a change of circumstance. If you don't, you could see your claim stopped or reduced, and you might have to cut your holiday short. You might have to pay a fine worth between $350 and $5 grand. This is because not reporting a change of circumstance would be classed as benefit fraud. How is going on holiday reporting a change? I don't get that. I don't understand that. And this is another thing as well that I was thinking about earlier, right? So the comment, when people are obviously being asked for their bank statements for the last 4 months and things like that, and people are challenging it, as I said before, we're governed in the law of contracts. So if you've signed, I don't even know if it's classed as a contract, Universal Credit, I presume it probably will be, that you will clear any commitments that they decide to put on your to-do list. So if you sign something to say you'll clear that to-do list, that means that they can put anything on that to-do list they want. Again, I'm no lawyer, but there has to be some illegality to that. I'm not sure if there's any lawyers out there that can shed some light on that. I'd be grateful for that. But this is the same thing. This is why I want to bring this up, because it's breaching human rights. You're allowed to limit your work hours, you're allowed to have a rest. Many people on Universal Credit are working. Yes, they receive Universal Credit benefits, but they're still working, so they deserve to have a rest. You try to tell me that they're not going to go on holidays? I mean, I don't know how many can afford it now anyway, but let's say you could. They've now been hit with this nonsense that there'll be 350 and 5 grand. I mean, normally I wouldn't read anything the Sun had said, but this, I wouldn't be surprised if this is true. Thankfully, we've got the Freedom of Information request, and you've also got your request that you can find out what they know through that. I'll post a link for that as well. We need to start using our power and realising we're allowed to ask these questions. I know it's hard to believe sometimes with the way society conducts itself, but we are allowed to answer these questions. And they're saying now that this is why I'm bringing it up with the commitments. They're changing this all the time with things like this. If you sign to the commitments, I think they should be saying, well, what exactly are those commitments? Because they say a lot of the time, this list's not exhaustive. So attend appointments, answer phone calls, look for work. Right, okay, that's all fine. But it doesn't say anything about me revealing anything private and confidential to you. But that is essentially what you're asking for when you're asking for bank statements. If you land yourself in this, you can see benefits frozen where their account is being investigated. You might even have to go to court. I mean, anyone reading that's not in the game or not thinking correctly or don't know anything or just new to this stuff, they would be. If you're thinking about booking a holiday with your family after reading that, you'd be thinking twice. In fact, I know people that wouldn't go through it. They would absolutely shite themselves. The arse would fall out their trousers and they would hit the local beach and save some money. How long can I stay abroad and still receive benefits? There are limits on how long you can stay abroad and carry receive your right. I mean, I'm not even going to get into this bullshit because I've been through it before with regards to what they've done with that, and I've had my own experiences with the work coach one time who didn't want a Slovakian kid to go back and visit his family with his new wife and his newborn baby that they hadn't met because she believed that he needed to be in his commitment back here, and I got her told that. She says, look, I'm not really bothered what you're saying, like, but this guy, he needs a holiday form of the document that replaces it, and I don't know. That's the thing about it. You don't know if you actually get that. If you don't actually know what happens after that, but I would like to think it would have had an effect. Now, I know I've not went through a whole lot of the case law because again, I'm not a lawyer, but you can challenge these deductions and you can start leaving a journal message on whatever these deductions are to say that, well, you've not received any phone calls from any companies, energy or otherwise, or water companies to discuss how much, and I've said it many times, they need to call you and discuss, first and foremost, if you owe the bloody money, how much you owe and how much you can afford to pay. If they've not done any of that, it's all unlawful. And if the DWP are telling you that they cannot stop the deductions, that's unlawful, that's wrong, that is, for some people it's misinformation, but at the top it's disinformation. It's purposely put there because they want you to believe their bloody lies. It's as simple as that. Yeah, you challenge it under the Human Rights Act 1998 because it's being breached. Going through it, you can go through the independent case examiner or claimants, MP, you can make a thing at your MP. Yeah, sorry, an application. Your MP can make an application to the Parliamentary and Health Service Ombudsman. The Parliamentary and Health Service Ombudsman. I mean, obviously I've put in the complaints email that you can start this stuff off with, and I would honest to God, we need to start doing this stuff, and we need to start putting the fight in, and the more people that put this through, the more the arsehole fall out their trousers, and they will have to start giving this money back. I mean, they're in big trouble here with this stuff, because the case law is what makes the law. I'll say it again, and the case law is there. And as I said before, it's not a debt collection service for creditors. It's a last resort third party deductions. But so a lot of these companies are it's a first resort. And don't get me wrong. I mean, at the end of the day, there's companies out there that if you're getting energy, you need to pay for it. Of course, you need to keep but there again, that goes into something deeper. They're thieves, like, but. On the basis of it, they obviously need to keep their company running. If you're using, if they're having to pay for something that you're then getting off of them, then you need to pay for it too. That's fine. I've got no problems with that. And there is people out there that don't pay it, and it does cause a lot of problems. But again, that doesn't change the fact that they are not contacting anyone. See, that would maybe stand up for them if they'd actually get in contact with some people to say, look, well, you owe this is why you owe it, and how much can you pay back? But they're not even doing that, and it's just I mean, this another note I've taken. That manager I was speaking about that was part of the court proceedings. She had sent out a communication to two DWP third-party deduction sites, Barnsley and Handsworth, informing them that claimants were being misinformed that TVs could not be stopped by DWP, and that the claimants were not being offered the opportunity to dispute. So they've said themselves that that's wrong, like, that they're not allowed to do that. So I hope I've been clear with this stuff, and if anybody's got any questions, honestly, I'll try and answer them as best I can, because again, this is not my forte. I was a wee bit mixed up with this stuff. I got a wee bit overwhelmed with it all, because there is a lot of information here. But I wanted to keep it to the third party deductions, because that's what people are having problems with now. Neil, obviously his deduction was for his council tax that he hadn't paid, but he had successfully proven that there is no document to suggest that he needs to pay that. So if that's true for Neil, that's true for everyone else. And you can challenge it under this. In fact, I might even just do, once I read more about Neil's story with regards to his own story, his own court case, I might actually do a separate video about council tax, because it is something I've always wanted to learn about and things like that. So I'll probably do a separate video, because I think Neil's story deserves something like that, because he's a decent fella. I mean, he didn't have to. He contacted me out the blue, and he said, look, this is the information, this is my experience, and he didn't have to do that. And he's obviously spent time doing it, and he spent time on the phone speaking to me, and I'm just very grateful to him. And I said that to him because obviously without him giving me this, I can't pass it along to you, or try and give it to you, or relay it back to you in a way that you can use it to then challenge these people. So it's using the same processes that I've mentioned, adding just a wee bit of this terminology and reminding that you've got human rights, you've got power. They've put it in documents, they've written it into law that you deserve to be looked after, you deserve a quality of life, and these bastards aren't giving you it, because they're taking it from you, because they're putting deductions onto accounts without consulting anybody, really. And then the scumbag agents or case managers or whoever are just, oh yeah, that's okay, that's right, don't worry about it. But I can tell you now, because the case manager I had a run-in with just not that long ago, he's getting a message from me just in the next coming couple of days, because he needs to know this stuff more than anyone. I mean, I'd hit him with some stuff from the law and that, but he wasn't seeming to be bothered. But I didn't have this case law at the time, so I'll certainly be sending that back to them, and you should as well. And just remember that there is rights. We've got rights. The United Nations, I know people have got their grievances with it, but we need to use their own words against them. We are afforded a quality of life, social security, health, education, developed person, all that stuff. But how the hell are you supposed to develop your personality when you've not even got a work coach that can try and help you get back into employment? All he's worried about is ticking you off his bloody list or whatever. I mean, I had a quick story. I had the work coach I had just before Christmas, before I'd done these videos, and he honest to God, it was like 11:30 in the morning, and his hair was everywhere. I hope he sees this, because he knows who he is. His bloody tie wasn't fixed, his shirt, he needed an iron, obviously. It didn't look like he'd been in the bloody shower that day. And I thought to myself, imagine, right, if I'm a young guy that's just been in a job, I was 17 till I was 21 and I lost it, and I don't know anything about the system or the benefit system, and I went in, up, bright-eyed, bushy-tailed, dressed, ready to go, to speak to the guy that's going to coach me, back into my next venture or my next position. And then you get into the bloody job centre and you see that clown sitting there at 11:30 in the morning. He's not even the decency to brush his bloody hair. And that would be enough to dishearten someone. So people like that are contributing to this, and I've had to complain about him. He was a scumbag, like an utter scumbag of a man, and he is the reason that this process is flourishing the way it is, and people are being pushed into hardship. And I told him that. He also laughed at me because, like I'd said to him, I was going to do these videos, and he laughed like. And then after I posted the first video, like when I had the next appointment, I think at this point I had like 130,000 views. He ended up terminating the call on me because he couldn't handle the fact that I proved them wrong. It was a satisfying moment, like, and you can have one of those moments too. They're not all like that. There is helpful people out there. There's no doubt about it. I've spoke to many work coaches that. They contact me every day, or not every day, like, but they do contact me just to say, look, if there's anything. I've got a guy that done it a couple of weeks ago. He just says, look, any changes and I'll let you know. There's not too much changing just now, because it's working pretty well for them, like, but things need to start changing with regards to us, because they're not going to change anything. We need to start showing them that we know what the law is, we know what our rights are, we know how to challenge, and we're prepared to do that. As soon as we start doing that, this game will change, people, I can promise you that. And I'll help anyone through it. There's people I need to contact. There's a guy that been damaged by AstraZeneca. He's just replied to me. I'll get back to him today or tomorrow to set up a call. Obviously that's probably going to be one of the next videos, and I need to do this. Just quickly show you here. I got this sent here when I done the bloody Shylight video. Trust me, I had the wrong one. I thought it was the right one. It was Mum that bought that one, but it wasn't. But Annabella from the company was kind enough, in Florida, was kind enough to send me this and some capsules to review them, and I've been doing it for 2 weeks now, and I'll tell you, it's brilliant stuff, but I'll go into it in the video. I just want to thank everyone for being patient with me and waiting for me to record this video. It's not quite turned out as well as I'd like, but it's all it matters is the information, and that you know what your rights are, and you know what to challenge this under and how to challenge it. That's really all that matters. Like I say, I'll go into further detail on the council tax one. I'll need to speak to Neil again anyway, because obviously after he sees this video, I'm going to ask him what he thinks. Again, I just want to thank you all. I wish you all the best, and I will see you on the next one. I'm going to get a live stream sorted out. I was hoping I might be able to do it on Thursday. I don't want to make any promises, but I'm going to try and get it done on Thursday night. Again, I just want to thank everyone for continuing to support me, and I'll continue to post as many videos as I'm able to. Thank you very much, and enjoy the rest of your evening. See you in the next one.